Hey everybody, John Skiba here, and in this video, we're going to discuss whether you are going to have to testify at your debt collection trial. But first, if this is your first time here to my YouTube channel, go ahead and click subscribe, and you can join the thousands of other people that receive notifications each and every week about how you can deal with serious debt problems. All right, let's talk about trials and whether you are going to have to actually testify if your debt collection case goes to trial. Now, this is a civil case, so it's a little bit different than criminal cases and the rules as far as testifying. There's also some strategy involved that you ought to take into consideration as far as how you prepare for your debt collection trial. So if you show up to trial, let's say you're representing yourself and you go to trial, you may be surprised to learn that the debt buyer, the debt collector, they can call you as a witness and the court will require you to go up there and testify. Some people believe that if they're in court, that they can invoke their Fifth Amendment right against self-incrimination. That's true if this were a criminal matter, but because this is a civil case, you don't have those same Fifth Amendment protections, and they can require you to actually go up there and testify essentially against yourself. And that's why often you'll see when consumers and defendants are represented by attorneys, often the client doesn't even go to trial. I almost never call my clients to come in and testify unless there's like an identity theft type issue going on. And so often my clients aren't required to attend because if they're represented by counsel, they don't have to be there. I could represent their interests. And often the junk debt buyer and that they don't have sufficient witnesses to be able to get their documents admitted into evidence. They usually only have a representative from their specific company that they're working for. So the thing to be aware of is if you're going to represent yourself and the case is actually going to trial, you're probably going to be called as a witness. They're going to have you come up and ask you questions as far as whether you admit having the underlying account. They may even use you to try to authenticate some of the documents like the monthly statements because they're not going to have a witness there from the original creditor. So the short answer is if you're representing yourself, you go to trial, you're going to likely be called as a witness, and the court will require you to come up there and testify under oath as to how the situation is playing out. If you're represented by counsel, even if you have an attorney and you're there, you can be called to testify. But often what I see is that many attorneys don't plan on calling their clients, and so their clients don't even attend the trials, and then they're not called. They can't be forced to attend unless a little asterisk here, unless the debt collector, the plaintiff, if they submit a subpoena to the court and they subpoena you to attend. I've had that happen in my cases before, where the plaintiff wants to have my client, they want to be able to question my client on the stand, and they'll actually get a subpoena issued by the court. Then you do have to appear, otherwise you can be found in contempt, and that opens up a whole other bunch of problems that you don't need. So hopefully that helps if you are representing yourself in a debt collection trial, just as far as what you need to be prepared for. I'll put a link down in the notes here in the comments. I have actually an online tutorial that kind of prepares you for trial and what to expect and goes into a lot more detail than what we did here in this video today. But I appreciate you watching.